Welcome, everybody. We are going to dive in. We want to give everybody their full hour. We have two terrific panels for you. We're looking forward to hearing from both panels. And this is probably our 15th year hosting the annual Labor and Employment event at Northeastern Law. We have a rich history in this field. And like I said a few minutes ago, probably thanks in no small part to Carl Clare, who's joined us tonight as well. But we have folks representing all sides of this field, and thrilled to have nearly 100 people RSVP to join us. I know Stephen is going to talk about this, but I wanted to just say really quickly, we're so grateful to Mark Irvings for initiating this program over the years. He really kept it running smoothly and always came up with creative topics. And I'm just really grateful to Mark. Stephen will talk about that in more depth. We're so pleased to have Member Prouty with us. Thank you for joining us. Carl told me about a month ago, it's like having a Supreme Court justice join us. So I was really excited to learn that, and we're thrilled to have you with us. A special thanks to our advisory group. I am so grateful that Stephen stepped forward, and grateful to Jeff and Josh Nedro for picking up the mantle and running with Mark's torch and really making this an event to remember. So thank you both. With that being said, thank you to everyone for joining us, and I turn it over to Stephen.
Thank you, Miel. And listen, many kudos to you and your office for attracting over 100 registrants to tonight's program. It's really terrific. And as Miel noted, for many years, Mark Irvings organized this program. So Mark, thank you. We are much indebted to you for sustaining the program each year. And as you probably noted, it's required 3 alums, Jeffrey Dentler, Josh Nedro, and myself, to organize this year's program in your stead. Jeff will be introducing the employment segment when we get to that. And while we've invited wonderful labor and employment panelists, leading off with newly appointed NLRB member David Prouty, who we consider an honorary member of the class of '86, we do not expect to cover nearly all that has transpired in the world of labor and employment since the pandemic when Mark last gathered us. So instead, we should understand tonight as the beginning of discussions that we will need to continue. So hopefully others will join Miel and her office in organizing future programming, and Miel will be putting her contact information in the chat so that you can contact her directly. Tonight's lead-off labor panel will be moderated by Valerie Jackson, who is a 2013 alum. And before Valerie introduces the panel, allow me to note that Valerie is an associate at JacksonLewis, where her practice focuses on traditional labor law issues. She routinely advises higher education institutions, healthcare systems, and other clients in New England and throughout the country on their rights and obligations in the unionized workplace. Valerie is a member of the Boston Bar Association's Labor and Employment Law Committee, Steering Committee. So thank you, Valerie, and I'll leave you to introduce the labor panel.
Great. Thank you so much, Stephen, for that introduction. Welcome, everyone. I have the pleasure of introducing our panel, and we are honored to have with us tonight Board Member David Prouty. I will give him a brief introduction. Member Prouty was nominated by President Biden to the board on June 23rd, 2021, and confirmed on July 28th, serving a term until August 2026. Prior to his appointment, Member Prouty also served as General Counsel of SEIU Local 32BJ. He also served as General Counsel of the Major League Baseball Players Association, and prior to that as Chief Labor Counsel. Prior to that, Member Prouty was General Counsel of Unite Here, and then also prior to that as General Counsel of Unite. Member Prouty received his BA from Bowdoin and his JD from Harvard, but we will forgive him for that. We also have with us today Desiree Murphy. She's a Senior Labor and Employment Relations Specialist at UMass Memorial Med, where she is responsible for managing the medical center's union relationship and facilitating its collective bargaining obligations. Prior to joining UMass, Desiree was an associate at Morgan, Brown & Joy, and she is also a 2013 grad of NUSL. We also have Jasper Groner, who's an associate at Segal Roitman. Jasper represents and advises unions, individual employees, and fringe benefit funds. Prior to joining Segal Roitman, Jasper was a clerk to Judge Peter W. Agnes, Jr. of the Mass Appeals Court and Jasper is a 2011 grad of NUSL. So thank you all for joining us on this panel. And first, to start things off, I would like to turn it over to Member Prouty to give us a bit of background and the insights into the day-to-day life of a new board member.
Well, thank you. Valerie said I did go to that other law school across the river. But as Steve also said, I do consider myself an honorary Northeastern graduate. When I was in law school, I actually lived with all Northeastern students, and because of the co-op program, and also because of the good looks of my friend Steve and my friend Ben Grant, I got to know just about all the members of the co-op of the class of 1986 because they all rotated in and out of our apartment. So let me just say hi to all of them. I saw a number of them who are on here. And then let me also just say, as Mayal said, I was lucky enough when I was in law school to sit in occasionally on a Carl Clare labor law class. So I just want to pay tribute to Carl and what I learned from him, both from hearing him speak and reading what he's written. And if Carl said having me is like having a Supreme Court justice, I feel like being with Carl is really being in the presence of royalty. So I'm not sure he'd like that, but hello, Carl, anyhow. As Valerie said, I'm the newest member of the NLRB. I was sworn in August. I have a 5-year term, which ends in August of 2026. I did serve as a union lawyer for 35 years and as an organizer and also a researcher before that. But now, of course, I have a different role as a neutral deciding cases along with 4 other members of the board. I guess I should add that so far there are 4 other members of the board and I'm getting along with them and I even like them so far. So that's a good sign, I guess. I was asked to talk a little bit about what it's like to be a board member. So I will. First, I should say that we have a great staff of lawyers. I actually, on my particular staff, and they're all career attorneys. They're all dedicated to the act. And they all frankly know a lot more about labor law than I do. I want to give a little plug also to the other lawyers who work for the board, both in Washington and also out in the field, which is where most of the work of the labor board is done. And they're the unsung heroes of enforcing the National Labor Relations Act, which is important to all of us. And I should also add, I know from firsthand experience that there are a lot of Northeastern grads, both out in the field and in Washington, and also working on both sides of the labor management spectrum. So what do I do all day? Well, it's the short answer, of course, is that we decide the cases that come before us. These are kind of caught up in what they call pre-sub meetings. And one thing you'll get from my presentation is that there's a lot of lingo in many fields, and the NLRB is no exception. And a lot of stuff I had to learn about shorthand. But pre-sub meetings, what they are is meetings where you talk about cases with your staff, and it's a totally new process to me. What I thought I would do is just kind of walk through what a meeting is like, and I can't take credit for this. An NLRB member named Peter Herkin, who was actually a management lawyer many years ago, gave a version of this presentation about what I'm about to do, just to illustrate exactly how these cases are decided and what it's like walking into the world of being an NLRB member. So the process is I gather my team every day. Now it's by Zoom. To be in person. So my team would be the chief counsel, the deputy chief counsel, a supervisor, and then a staff lawyer who handled the case. And they would present it to me kind of like an oral argument. And this happens all the time, several times a day, every day, and the cases just kind of keep coming to us. So here's kind of a typical hypothetical about how these meetings go. And this is where I should say what I've come to refer to as the case name code game comes up, because you hear it, again, as I said, a lot of lingo that you don't understand. So here we go. Staff lawyer starts off. Good morning, Member Prouty. By the way, they all call me Member Prouty. I can't seem to shake it. This is an unfair labor practice case, and the facts are very similar to the cotton swabs decision. Supervisor says, yes, but there is also a frickin' frack motor freight issue embedded in there. Deputy chief then has to chime in, so they say that issue. Staff lawyer says, well, she resolved it against the company's supervisor, and then turns to me and says, you should too. Chief counsel then weighs in. The chief counsel in my case is a lawyer who is an ALJ named David Goldman. Thankfully, he is an encyclopedia of board law, so I don't have to be, and I'm certainly not yet. So the chief counsel weighs in. Okay, but did the ALJ deal with the application of cotton swabs too? Staff lawyer says, yes, she did. So then Goldman can kind of wax eloquent, and he'll say to me, okay, Member Prouty, here's what we have. This is just a cotton swabs 2 case with a frickin' frack evidentiary application. So how do you want to decide it? But before you answer, you need to think about this too. If you want to uphold the ALJ decision, do you agree with this requirement of a continental flange remedy? I then usually say, because that's all I have really to contribute to the discussion. So that's my experience so far, and I guess I'm learning it along the way. Now, cotton swabs, of course, is not a real case, but one of the things I think you've got to love about labor law is this: the cases, because along the way, I think you've got to love labor law. Some of what I'm about to read to you, you'll know. They're basically names of employers, but what other field of law, I would submit, has such interesting names that you get to throw around all day? So I made a little list of 10 case names, and these are all case names that some of you will recognize that get thrown around just like cotton swabs. Extra points, and you can put it in the chat if you can tell me what the cases are about. So here's my list: Johnny's Poultry, Struxness Construction, Excelsior Underwear, Master Slack, Clear Pine Moldings, a case we just decided a little while ago called Windy City Cannabis. And you'll love this, and it's true. It's located on Weed Street in Chicago. Standard Drywall Products, Spruce Up, big case. King Supers, and Supers is spelled S-O-O-P-E-R-S. And then my favorite case, another one we just decided, kind of sums it all up: New Concepts for Living. Those are all names of employers. As I said, the staff that I have makes me look good. And what they do is, for every one of these cases that I hear, they present me with both a bench memo, which is usually 10, 12 pages, outlining the entire case, and then also their view of what they think I would be interested in about the case, and they're kind of getting to know me and know what my predilections are and where I might come out on various cases. So for every one of those, I get those 2 documents. So I spend an awful lot of my time reading over the documents and thinking about them. And it's really a great luxury both to have the chance to do this and to have such a great staff backing me up. So let me just say in conclusion, and I'm happy to answer questions, and I'd rather frankly spend time doing that, that as I said in my swearing in ceremony, to me, the National Labor Relations Act is all about promoting and protecting collective bargaining. That's what it's for. If you follow the news lately, if you've been watching Starbucks and Amazon and all those cases, and if you listen to the other panelists who are going to follow me, you'll know that it appears that we're really in a period of resurgence for labor law. And I think that's good for working people. I think it's good for the economy. I think it's good for the country. And I'm very proud and pleased to be part of it. So let me stop there, Valerie. And I don't know if you want to take questions now or wait. And I would suggest maybe we go through the rest of the panel first. But thank you all. And again, it's great to see everyone here.
Absolutely. Thank you so much, Member Prouty, for those insights and discussions into your role as a board member. So what we're going to do now is we're going to shift gears and talk about a few substantive issues that are on the minds of union and management lawyers are alike, and look at and discuss how the Biden board is poised to review and revise the law. If you do have questions for our panel during these discussions, please submit them to me in the chat, and I will post them to our panel during this discussion. But why don't we get started with Desiree Murphy, if you could start us off.
Sure thing. So I'm going to be kicking a conversation off with a brief, emphasis brief, entry point on impact bargaining during COVID-19. So no groans, it's going to be brief, guys. I think when I think about this particular subject, I think the biggest change really wasn't the rules of engagement, and I'll get to that in a second, but rather the expanse of the issue itself, right? We're talking about a pervasive problem that is literally the air you're breathing. And I think that did a couple of things, right? It created this emergency situation where many industries were, struggling with what to do. In the beginning of all this, there was a gap in terms of administrative guidance. So you really had the parties of the labor relations really trying to figure this out. And I think the initial question was, well, given this is an emergency, can we as employers just unilaterally, make these decisions? And the answer is no. And to that's my earlier point. The rules of engagement are still the same. You have to impact bargain and decisional bargain where you have discretion. And that's remained the case even as we've gotten the guidance that we were missing in the beginning, the now probably void EPS standard for our employers in the private sector. That GC memo that came out around that time explicitly stated that in those areas where the mandate isn't, clear and you have options, those options need to be bargained through from the decisional aspect. And I think, again, in that format, right, where we're having the parties themselves try to figure it out, a lot of band-aids were created, hazard pay, incentive pay for picking up extra shifts and critical staffing, extended sick leave programs, all of which, were meant to get us through. But I think the question now for everyone, right, is we're clearly not leaving this time period. This is clearly going to be the life that we live. And I think for everyone, employers and employees alike, the question is, what's the long-term strategy? And I think, and Jasper, I'm interested to hear what you think about this in particular. I think it's going to play out in a couple of ways, right? I think in some aspects, right, there'll be some direct conversations at the bargaining tables about, workplace safety. And I think, some of the traditional clauses that we're used to seeing are going to become more robust and talk about a lot of the issues that we've been, again, impact bargaining over the course of the last couple of years. I think the other major way that we're all going to see this, right, particularly in industries like healthcare, where, again, this is our bread and butter, it's going to show up in the meat and potatoes of the contract, the wages, the benefits, and coming up with the structure that, again, reflects the time period that we're in. And I think there's going to be some hard conversations for employers. Lines are going to have to be drawn. But I think that's the direction we're heading, considering, again, the long-lasting effects of where we're at with this pandemic. So I'll stop there and open it up to you, Jasper.
Yeah, I mean, I think that's a good summary. I guess a couple things I'd add to that is that a push that I have seen and that has been vigorously opposed by clients I've represented has been for language that would allow employers to act unilaterally in situations like this. And there's certainly, I guess, a feeling amongst employers that they want to take unilateral actions, like Desiree said. And except for my one client that somehow had language specifically about epidemics allowing unilateral action in their contract since the 70s. Who knows? That's generally not in there. And so there's been a lot of push and pull, particularly in industries that were really heavily affected by this. And what I will say is, I think Desiree was sort of alluding to this, I do think there was a lot of very productive bargaining here, because it was a situation that neither of the parties anticipated. And in a situation where in a lot of ways, if, it's an employer who cares about their employees that says some,
Right.
and some do, there's a way that the interests aligned. I've had some of my most, mutually beneficial bargaining on this topic, and some of my least mutually beneficial bargaining on it. And I think it really depends on the perspectives of the people involved, but it's definitely a situation that's not going away. And I think we'll have ramifications in contracts for years to come.
No, absolutely, Jasper. And I'll just add, you're absolutely right. I think this is an area, right, where the relationship hit the road, right? If you had good bargaining relationships with your union partners, having these conversations was not only productive, but yielded, again, some, understandings that we could work by. And again, probably won't be unforeign when you do get to the table. I think it's those contentious relationships that existed that were exacerbated by this, where you kind of see that tension of, again, is it your call to make, or should there be more parameters that we discuss, and whether an employer is willing to do that or not, like you mentioned. So yeah, absolutely.
Okay, great. No, and that what you both have said is consistent with my experience with all of that, impact bargaining, decisional bargaining we've done. And like Desiree said, it's not going away, but what's key that you both touched on is it's the relationship, it's the early communication, it's the working together. And those are, while it was very difficult for both sides of the table, those doing it that way, you did yield the most, I would argue, mutually beneficial outcomes. And so with that, Jasper, I am going to turn it over next to you. Do you want to say a little bit about employer handbook rules? Maybe
Sure.
Just a little, yeah.
Yeah. So this has been a hot topic, I think, in both the current Trump board, the previous Trump board and the previous Obama board before that, and it's probably going to continue to be a hot topic in the Biden board. Just to give a very brief doctrinal overview, the sort of back and forth in this started with a case called Lutheran Heritage Village, Livonia, that came out in 2004, and it had several ways in which you could look at a handbook and determine that even if a provision in it didn't specifically and explicitly affect Section 7 rights, it would nonetheless inhibit them. It would make it so people could not engage in protected concerted activity. And the most relevant one for our purposes today was that if an employee could reasonably construe a handbook to inhibit Section 7 rights, then those provisions would be struck down. They would be found to be a violation of 8A1. And one of the sort of the places where that got interesting was around sort of civility language. And there was a lot of fine-grained distinctions drawn from about 2004 until 2017, when the Boeing case came out, which was in the Trump board. Many of those decisions drew fierce dissents from member Miskamara, who went on to pen the Boeing case and cite to the confusion and disagreements about the prior cases based on his own dissents, but that's neither here nor there. The Boeing case shifted a bit of the focus on here. It said that instead of looking at this from the perspective of a reasonable employee, the board would, on its own, say, can you reasonably interpret this to affect Section 7 rights? And then you have to balance that against employer interests. And based on that balancing, rules could fall into three categories. They could be either always lawful, sometimes lawful with individualized inquiries, and never lawful. And so there's a lot of focus on sort of categorical looks at rules. And as a result of that, and there's a few cases that just sort of like sprung out of that, many having to do with confidentiality. There was a case called Apogee Retail where the NLRB found that confidentiality instructions during workplace investigations were always legal. So you can't talk with your fellow workers when you're being investigated. There was the Baylor University Medical Center case, which said that no, confidentiality and non-disparagement clauses and separation agreements were always legal. And there was the California Commerce Club case, which said confidentiality clauses and sort of individual arbitration agreements, that often the sort of ones you get handed when you walk in the door and have no say in, were always legal. And I think that, I can speak most to Apogee. Before, it was really case by case looking at them. Was there a specific reason that you needed confidentiality here? And the way that I see this and is that it seems like the board was really looking at this very much from the employer's perspective. It was looking at it, when an employer is conducting a workplace investigation, what could corrupt the investigation? But that assumes, so sticking with the Apogee example, that the employer is operating in good faith and that the employees discussing things with each other would be operating in bad faith, that they would be trying to hide the truth from the employer rather than protect themselves from a frivolous investigation, retaliatory one, whatever it may be. And it's, I think, significant, and I think that this is something that the current board hopefully will see in a different light, that in that formulation, the rights that are protected by the NLRA, the Section 7 rights to protected concerted activities, were outweighed by rights that aren't listed anywhere in the NLRA, which was the employer's legitimate business interest. There's no protection for that in the text of the NLRA. And so we'll see how that goes going forward. I think that there will be a shift back in focus, and hopefully some of these cases get reversed. NLRB-GC has asked that cases on this be submitted to advice, and there's currently pending the Stericycle case where the board has invited briefs on whether to overrule Boeing, whether to return to the Lutheran Heritage Standard or to go to some other standard. And so that's very much something coming in the near future, what will happen with that doctrine. And I'll hand it over to Desiree.
Yeah, no, I think you're right, Jasper. This is going to be a wait and see situation. I think it's been a wait and see for a while. We talked about that a little bit before during our prep session, that this wasn't one of those areas where employers just jumped to change everything because we got a good decision. I think there was still an inclination to be cautious. I think when I think about the Boeing case, and it's the POGI, and I think the case we even talked about last week, Jasper, Dish Network. Yeah. Right, there's a tension for me, right, in terms of, I think you termed it as the board looking at it from the employer perspective. I think from my perspective, it's more so balancing, right, and trying to make sure that this really is a equal weighted analysis. I do think that in some ways, when I think about the cases, handbook cases prior to Boeing, I felt like there was this, almost supplanting of the employer's judgment in terms of the wording, right, in the language. Oh, this could be worded clearer, which I think that's a subjective inquiry in itself, and it doesn't even get to the meat of the issue when it comes to ambiguity, because I think it's more than just what the words say, it's how it's implemented, what's the practice. And I think if you have a rule that doesn't necessarily explicitly say this doesn't apply to Section 7 rights, but is applied in that way, there's no ambiguity. You've trained your people appropriately, everybody knows how this is supposed to work. Why should that be invalidated? Particularly like in Dish Network, where it was just one instance that was inappropriately applied. Let's address that one instance. Whether it comes through a ULP or some other proactive measures on the employer, but let's not invalidate a whole concept as far as a policy, because it could be written a certain way. Again, I think that could be, just gives me pause, because I feel like we could always say that it could be written different. If the circumstances were such that, again, there's evidence that people are not understanding it, i.e. you have a plethora of incidents where people are inappropriately applying the rule, then again, I think, yeah, you have an ambiguity problem. Yeah, there's something to be said here for rewriting this. But I think absent that, and it didn't seem like the previous cases took that into consideration.
Yeah, I guess what I'd briefly say in response to that is that, I think that the previous cases properly acknowledge the power balance between an employer and an employee, and that employees are by and large kind of afraid of their employers. They depend on them for their livelihood, and the notion of being fired is a terrifying prospect. And when you've got a rule that could say, oh, if I talk to Billy about my boss, I'm going to get fired if I, swear a little bit, you might be a little more reluctant to do that. And so the wording of those rules is really important in terms of, if someone reads it, what they feel comfortable doing and whether it will chill them from exercising those rights, even if they're not explicitly prohibited from it.
I guess that still ignores the fact that Billy must have done something to promote that chilling effect. I mean, that to me, again, you still have to go beyond the rules. If Billy is being that supervisor who gives that indication that, you can't, I'm gonna, again,
Billy was the coworker he was talking to, but that's okay.
Whatever the case may be, my point is to me that I think if we're talking about what a rule means, you can't just look at the language and say, okay, that's how people are taking it. You have to look at how people are interacting with the rule and how they're moving around it, I think, to get to that answer. And I feel like focusing on the language is only part of that analysis. And I'm not saying that it's not relevant, but I think it's only part of the analysis. And I feel like sometimes the cases stopped there and said, okay, it's not explicitly in the rule. This person misapplied it. Okay, the whole thing's gone.
I think I could rebut, but I do think we've got other topics.
I know, we gotta move on. I know.
Yes,
I know. We only got 20 minutes. I'm sorry.
Right.
I'm sorry.
We have a very ambitious
I'll
agenda,
shut up.
and this is no. We're having
that
some
is not what I said,
excellent
Desiree.
discussions, but- right. A topic for further discussion, and I'm sure we will hear more from the board about this one. But moving on, I'm going to speak a little bit about a topic that has been before the board before and is now in the news today, not just at the board and not just with the GC, but with the recent changes in name, image, and likeness, and with the Alston decision, and that's NCAA scholarship athletes. So we're seeing changes to the way student athletes are being treated, challenges to amateurism, and what could be even the demise of amateurism in terms of college athletics, as like we've never seen before. And along with this change, we've also seen with the September 9th, 29th memo from GC Abruzzo, it outlining her prosecutorial position on this issue, that players, as she calls them, players at academic institutions, it's a mouthful, are employees under the Act. And this is going, in her memo, she's outlining her thoughts on this matter, more so than her predecessor, GC Griffin, in his memo. So what is a player at an academic institution? So this is a term that's used by GC Abruzzo in her memo. She outlines that calling them student athletes is a misclassification in her mind. The term could be construed to be a chilling effect on their Section 7 activity because they're, in her memo, she outlines that they're employees under the Act, not student athletes. And so accordingly, she's stating that she intends to pursue an independent violation of Section 8A1 if an employer, or college or university, but employer, misclassifies a player at an academic institution as a student athlete. So, and I think this should also be a takeaway for all employers, and is consistent with GC Abruzzo's prerogatives in her other memo, that she's going to be pursuing misclassification as an independent violation, not just for players at academic institutions, but for all industries. So I think that is a takeaway that we should, all employers and all industries should take from that. But she definitely makes it abundantly clear that that is going to be an independent violation of the Act there. So back to players at academic institutions, now covered as employees under the Act. So a little bit of history on this. GC Abruzzo in her memo cites Northwestern. That's where the board declined to exercise jurisdiction over Northwestern's D1 FBS football scholarship athletes, but didn't decide on whether they were employees under the Act or not. Then GC Griffin issued his memo asserting that Northwestern and other scholarship football players at D1 FBS private colleges and universities would be considered employees under the Act. So just, limited to the D1 FBS athletes. Here, so GC Abruzzo with her memo, she's reinstating GC Griffin's memo to the extent it's consistent with hers, makes it clear that it's not limited to football, not limited to FBS football, any other kind of football, that similar scholarship athletes at academic institutions are employees and should be afforded the protections of the Act. What student athletes that covers is certainly up for discussion. GC Abruzzo discusses the revenue generated by scholarship athletes for their institutions, the goodwill generated in terms of football, but what does that look like for sports that have scholarship athletes that maybe don't have ticket sales, don't have those TV deals? Is goodwill enough? What do we consider revenue? So all of these things we leave open for discussion, but I think it's safe to say that if the GC makes it very clear that our goal is that they are employees under the Act, I think the safest reading would be that the broadest brush would be the most probably what she would be looking for. Also, interestingly, she makes it clear that she's would also pursue charges against an athletic conference, even if the member schools in the athletic conference aren't just private institutions, if it also includes public colleges and universities. So public colleges and universities not covered under the Act, but the GC states that because of NCAA's control over member institutions and because of athletic conferences' own control, and those athletic conferences include private and public institutions, they could find a joint employer status with both private and public member institutions. So potentially public universities or colleges could come under the Act. Again, I think, in reading this, again, important to note in terms of the student athlete issue, I think it's also another indicator for employers in all industries about the GC's directives on joint employer status, and could be used to impose liability on employers who otherwise wouldn't come under the Act, as long as the entity that is covered by the Act is involved in setting some of the terms and conditions of employment for employees. So there's a lot I just went through, and there's a lot more in this memo, and there's a lot to unpack. So I would love to hear from Desiree or Jasper their thoughts on this. I'm gonna grab a drink of water because I just said through an entire memo, but maybe we'll start off with Jasper. Thoughts on this, and then I'd love to hear from Desiree as well.
So I think my brief comment is that I see this as a move in the right direction, and I think there's the public debate about compensation for student athletes is pretty well known. I think the doctrinal thing I'd point out is that I think the recent Supreme Court case, antitrust case on this topic, is going to loom large in future decisions on all levels in this, and particularly the fact that Kavanaugh, of all justices, basically excoriated the NCAA and said that what you're doing would be illegal in any other setting, and there's no special exemption for you. And I think that was from the perspective of a lot of folks who represent workers, that really is the core of it, is that there's this sort of amateurism in the college sports setting has this sort of talismanic feel to it, that it's, we say that and therefore we can do whatever we want. And I think that there's that hearing that from the Supreme Court and hearing it from a Republican appointed justice on the Supreme Court is going to have a really big effect going forward. That's all I got.
Well said, Jasper. I think, my comment on the actual substance is I would say that I feel like the writing's been on the wall for student athletes for a while, probably since, we saw the increase of graduate student organizing. I think everybody kind of said, okay, schools are definitely in the bracket now. I think as far as my comments in terms of, I think the point that you made, Valerie, in terms of the expansion, of joint employer under this general counsel's prerogatives, I think it's something that we've been down the road, right, with the joint employment concept overall when it comes to the board. As most of us and maybe all of us in this room know, the joint employment standard has gone through several iterations in of itself over the last several years. I think the turning point being that 2015 case that every management employer loves, Browning Ferris, which I think is notable, right? Because it was a pretty significant departure from the previous standard of joint employment under the board, which really focused on the employer's direct and immediate control over the workers. And I think, again, thinking about it in the context of student athletes, that when you're thinking about the universities and, colleges that are involved in this and their control over, the mechanisms at play here, it'll be interesting to see how that coincides with the work that's ultimately to come with the joint employment standard. Because even after, kind of going through this in the case law, as well as getting our final rule in 2020, we're now back at a place where we're, going to be looking at more rulemaking from the board on this as of their announcement from December of 2021. And I think when we look at that final rule that was done in April 2020, from my perspective, I think the board was trying to do a couple of things. One, get us back to pre-Browning Ferris in some respect, but also acknowledge, some of the points that were made by the DC Circuit in 2018 when it ruled on that case, and made some points about how Browning Ferris kind of overreached, and particularly overreached in this idea of indirect control being a significant factor, and indirect control not only in the sense of routine decisions, but also contractually reserved rights that not even exercised. And I think the DC Circuit highlighted, right, that in applying that standard, the board went beyond just the essential terms, but to any term of condition of employment, really, again, including these mundane decisions, and ultimately kind of expanded out, right, the potential for joint employment for employers, again, who are just probably more so engaging in more routine, non-outcome determinative decisions with their contractors. I think, again, the final rule seems to try to join those things together, again, bringing us back to that direct and immediate control, but also acknowledging that indirect control is relevant, particularly if it's indicative of the, ultimately substantive control that the potential joint employer shares with the other business. So in the end, with the, announcement of rulemaking, I think we all know here that the board has a few different options in how to approach this. I think in terms of potentially rescinding the rule that was issued in 2020, that's always there. And, we can go back to the case law and, whip back and forth there as we have been doing, or ultimately modify the 2020 rule. And I think if that's the case, then we're probably, as management attorneys, looking more to see of the Browning Ferris, concepts in that rule than not. So that's my take on that, as well as kind of going into the next subject on joint employment. I don't know, Jasper, if you have any, general thoughts about the joint employment standard. Again, I think it's an open question, again, to the extent that rulemaking's on the horizon.
Yeah, I mean, I think I agree with most of what you said, Desiree. I think I have slightly different perspectives on the Browning Ferris decision, unsurprisingly. But the point I guess I would make is more of a practical one, which is that, the point where this really impacts collective bargaining and impacts unions is when you get to the bargaining table and you're told, well, we can't make that decision because of X or Y person who's not here. And you can't force X or Y person to come to the table. So you just got to live with it. And that can happen in all manners of contexts, whether it's, someone who's a contractor on a job site, like a cleaning contractor who works for who's contracted with a skyscraper, whether it's someone who, operates a power plant in a manufacturing facility, whether it's a temp agency situation. And I think that the goal of the Browning-Ferris decision, you can debate whether it was the proper mechanism, was to make sure that you don't have these situations where you're bargaining with someone who's your employer but doesn't actually have the ability to set your terms and conditions of employment. It'll be interesting to see where it comes out. So I think that's my basic take on it. I do think. Sorry, did you have?
I think we have one more
else?
topic. No,
Yeah.
I think we just have one more topic if you want to go into that, Jasper.
And I think it's me, which is
Yeah.
we were gonna. You want to say something, Valerie?
No, I mean, what Desiree said. So why don't we segue right into you, Jasper?
Okay, thank you.
Take it away. Yeah. Thank
So
you.
the PRO Act, I'm gonna have to go very briefly on it. I mean, it's got about 10 to 15 different topics that are each the size of what we've discussed today. For those of you who don't know, it was an act passed by the House with bipartisan support. There were 5 Republicans who signed onto it. That has not made any headway in the Senate. I think unless and until there's reform to the filibuster or some massive wave of Democrats, it's unlikely to make any headway. But you never know. A few changes in seats come November, we could see a different result. And it addresses a lot of different things. And I'll just touch on them briefly. It addresses joint employers, which we just discussed. It addresses, the definition of employee, both in terms of, as opposed to as an independent contractor, when is there sufficient control? It would add in what's called the ABC test, which is what both Massachusetts and California have had for a number of years now to distinguish between the two of them, without, I would say, any of the catastrophes that were predicted from it by the management bar. Supervisor, there's a narrowing of supervisor with sort of the intent of making it so that someone occasionally takes on supervisory tasks. They're not suddenly rendered a supervisor by that. And also of 2 subsections of that, the assigning work and responsibly direct, which had encompassed a wide variety of things. It would overrule Mackey Radio, which was I believe 1930s, if not that 1940s case that said, well, of course, in an offhand comment, employers have the right to permanently replace strikers. And that's totally different from firing them. It would mean that you couldn't, quote unquote, permanently replace a striker explicitly in the act. It would eliminate the secondary boycott provisions. So that would be returning to a pre-Taft-Hartley Act version of the NLRA. So before the Taft-Hartley Act was passed, it was legal to boycott secondary employers, to picket them, et cetera, to try and bring pressure to bear on your primary employer who was dealing business with them. It would have interest arbitration in first contracts. So that's a situation where if you can't come to terms, you put it in front of an arbitrator to figure out what the contract says. Something that happens in like police and firefighters in Massachusetts and in a number of other states with some success there. It would rule class action waivers to be to violate the act. It would explicitly state that. It's a case that went before the Supreme Court recently, the Epic Systems case. It would essentially reverse that. It would amp up the damages provisions in the NLRA to be more consonant, I would say, with other employment statutes out there. Things like multiple damages and attorney's fees and the like, which you see in basically every statute but the NLRA. And also impose penalties for non-compliance by employers, which I think, from my perspective, is pretty common, is that there's not enough teeth to what's out there right now in terms of getting compliance. And I think it's a widely shared belief in the union bar that this is necessary for employers to not view violations as just a cost of doing business. It would overturn right to work, which is the laws, which were the state-by-state laws, which permit people to opt out of being in a union entirely and not pay for any of its services, but receive all the benefits of it. And it would allow for, I thought this was a really interesting one, whistleblower protections for not only people who are considered employees under the act, but under a broader version of employee that included management and supervisory employees. So if, for instance, you believed as a manager your employer was violating the act, you would have the right to go talk to the NLRB about it without getting fired for it, which is not currently what the act says. And so like all those pieces, we could talk about the pros and cons of them, no pun intended. But I think that it represents sort of a view that the NLRA has not been substantially revised in pretty much, I guess it's almost 70 years now. I think the last really major revision was probably in the 50s. There's some toying around with, or is it 49? It's Taft-Hartley Act was probably the last one, but there was some toying around in the edges in the 70s, and it's been unchanged since then. And that, you know, to reflect the modern world, to reflect the experiences of the last 100, almost 100 years, 90 years under the Wagner Act, that, you know, there are these changes that are needed to accomplish the goals of promoting collective bargaining under the Act. I'm sure that there's difference of opinions on many individual ones. And I guess one of the things that is expected, but still disappointing, is that there's not any vigorous debate in Congress about any of the topics of this. It's a flat no from the opponents of it. So that's my 2 cents on something that I'm sure we could spend $2 on.
Yeah, no, we certainly could. And I know we want to get to questions, so I won't belabor any comments, only to say that I think I've said this before. I don't know that the PRO Act is the way to go in terms of, as it's currently structured. I hear you, Jasper, and I would tend to agree that, you know, the NRA is outdated in terms of where we currently stand. And I also hear Member Prouty loud and clear that we are in a resurgence of the labor movement, which, you know, I am personally, if nothing else, for job security here for. So I'm not going to say that I'm, you know, I don't think conversation is needed. I think the expansiveness and also some of the issues that I just don't, I feel like that should be up to the relationship, which the relationships are meant to change and flow with time. And I think codifying some of these things in such a finite fashion takes some of that away. So that's all I'm going to say.
All right. Well, thank you both for such. I know we had a quick dive, but such a quick and comprehensive dive into some really crucial topics in our industry, and for the wonderful discussion. So now I would like to open it up to questions. You can either send them in the chat, and I will post them to the group, or you can, I think in Zoom, you can raise your hand. I think there's a function that Miel is shaking her head. Yes, raise your hand and ask any questions. I'd like to open it up for that.
Is there a question in the chat already for, it looks like it might be to Member Prouty from Galen?
Oh, yep, thanks. Yep. So I have a question here in the chat. It's labor union membership in the private sector has been decreasing for decades. Does the NLRB have a role in this decline or a duty to reverse it?
Well, let me say before I try to answer that briefly, I thought the presentations you just heard were great, and it shows there's a lot of very interesting issues you could go on and on about, and it was incredibly frustrating to me not to be able to weigh in. You know, I've been a union lawyer for years and years, and I wanted to say something, but of course, I was cautioned by the ethics people at the NLRB that I can't comment on anything that might be coming before the NLRB. So, labor union membership in the private sector has been decreasing. That is true. I don't think it's any secret that I would say that's too bad. Does the NLRB have a role in this decline or a duty to reverse it? Well, I think there is, as you heard Jasper say, there's a lot of proposals out there to strengthen the NLRB. I think it probably needs to be strengthened. I can only deal in my current role with the act as it's written before me. I don't know that the board has a duty to reverse it. I think that the duty that it has is to enforce it. And to me, enforcing it means protecting the rights of workers to engage in concerted activities, to organize into unions or not, if they choose not to, and to promote collective bargaining, which I think is a win-win for employers and for unions. So I'll stop there.
Great, thank you. Any other questions?
See a hand raised.
Earl has a question.
Hi, can you hear me? First, I want to say on behalf of the faculty how proud we are to have all of the speakers visiting the law school, and it's a particular matter of pride that Member Prouty has joined us. So thank you very, very much. My question is, if you're at liberty to answer this, what is the thinking or the mood of the current board on the in recent years, there's been quite a bit more use of or attempt to use the rulemaking power as distinct from case adjudication. Is that a trend that's likely to continue? Is there a sense that there might be a reversion back to a more case-by-case handling of matters? Anything you could say about that?
Sure. No, that's a great question, and I think it's no secret, and the panelists talked about it. The board put out a notice that we intend to take another look at the joint employer rule, whether we do that by formulating a new rule or just rescinding the old one. Not clear yet. There are several other rules that are out there that were put into place by the, I'll call it the Trump board, that are worth taking another look at. I think that's about all I can say about that. My own feeling 6 months into it is that proceed in this sense, and maybe in this sense only. It takes a long time. You've got to get your position ready. You've got to put your proposed rule out there. You've got to allow time for feedback, and then you've got to, under the APA, digest all of the feedback and respond to it. So it takes a long time, and it's a kind of an awkward way to see changes made in the law. So I think there's a place for it. I think probably I would err on the side of deciding cases by litigation where there are matters of law, and leave rulemaking to matters of procedure as a general proposition. That's kind of my current thinking about it.
Great, thank you so much. So we have a question in the chat from Nico Maruli. To Jasper, Desiree, how does the shifting nature of labor law, as you mentioned, joint employment and work rules, affect how you practice?
I mean, I think it depends on the issue, right? So, like, for example, like I said earlier, with employee handbooks, I think that was one of those where we've seen like that concept kind of go back and forth. So I think, you know, especially with the changing of the administrations and the timing of these cases, I think we all kind of looked at that and said, all right, was it legally sufficient before? Let's not, if it ain't broke, don't fix it. Let's leave it alone.
Right.
I do think, you know, in terms of, you know, some of the other issues with regard to like impact bargaining, again, I think it isn't so much the rules of the game, but really just the substance. And I think for me, I will say the emphasis on relationship, especially in the last 2 years, has become key. And maintaining those good relationships, collaborative as they can be, because we still have our managerial prerogatives. It has been, you know, an emphasis in terms of how I approach, you know, my work, particularly at the hospital.
Right, and I think that it's even in, or I'll turn to Jasper, I think it's even in the last, word of that question, practice. It's a practice, it's ongoing. That's, part of the reason why labor is so interesting to me is it's constantly changing. You constantly have to keep up. And Jasper, any thoughts on that?
Yeah, I mean, I think it really depends. So for instance, it depends on the issue. Work rules, I think, is probably on average going to be a bigger thing for people who are, on average affects non-union workplaces more, though I've dealt with actually an apogee issue in a union workplace since it was put into place. And I think would probably come up more for the management sidebar in terms of advising clients than, on average for us. I'd also, but on other ones, joint employer, I've had live issues where that's been an issue. One that we didn't talk about today, but that did, I think, had a very substantial impact on how I think about my practice was the change in the standard for contractual waiver of bargaining. So, which used to be a clear and unmistakable waiver, and it was shifted to contract coverage. And I've been a lot more reluctant to tell my clients if a change was made mid-contract to go to the board, because I think that under that standard, there's a lot of chances it'll just get kicked out. So it really depends on the issue. It really depends on the client. I mean, and I think to sort of pick up on what Desiree and Valerie were saying, for our clients that have long-term relationships, it can be less impactful what the rules are, because no one's skirting the rules at that point, and they have their ways of doing things that have been figured out. For newer relationships or more contentious relationships, it can be a big impact. So.
Great. And we're having some great discussion, and I see we have more questions, but I want to be mindful and considerate of our second panel. And I believe if I'm looking at Miel, our time is up. But thank you to my fellow panelists and Member Prouty, and it has been a pleasure.
Thank you, Valerie, too, for moderating, and thank you so much to the panelists. They're all terrific, and we'll move to our other panel. I'm going to turn to Jeff Dretler to moderate and handle that, introduce that panel. Thank you.
Thank you, everyone.
Hi.
Thanks, Steve. I'll just start the introductions. I'm very pleased to introduce Emma Laney, who is class of '97. There she is. She is currently the acting general counsel of the U.S. Department of Education and has been for most of 2021. She joined the Biden administration from the National Education Association, which represents over 3 million employees in educational workplaces. And for over 20 years, she has represented employees and their associations in various industries. And we're very, very privileged to have her joining us this evening and moderating our second panel, which is titled The Current State of Employer Obligations and Employee Rights in a COVID-19 Pandemic Workplace. And I'll now turn it over to Emma to introduce the other panelists and start the program. Thank you, Emma.
Thank you so much, Jeff. I'm really excited to get to this panel. It's been a pleasure preparing with Gavi and Seema and Kristen. Like Member Prouty, I got my share of cautions coming in tonight. And one of them is probably that I shouldn't misrepresent myself. I am no longer the acting general counsel. I'm the principal deputy. My boss is confirmed by the Senate, Lisa Brown. She's now our general counsel. So in case anyone watches this recording. And if I may, I'd like to blame Jeff for that. And so let me just introduce our panel. Seema Lynch is here. She's been practicing for over 30 years and focused on advising healthcare clients. So she's had major academic medical centers, individual health professionals, and everything in between, and many times on issues of employment law. She's in-house counsel now and has actually been at two organizations during this pandemic, both one in direct medical care and now at a biomed, a healthcare technology company. So we're thrilled that Seema's here. Gavi is here also, or as she may be more famously known, the president of the Massachusetts Employment Lawyers Association. Gabriella Bogan-Farber. Did I say your last name right? I practiced your first name. Okay. So now for nearly a decade, Gavi has represented individuals. So discrimination cases, retaliation, and negotiation of reasonable accommodation. So she's a member of Sheeran and Lodgen's Employment Law Department, which I looked up and is an award-winning department within that firm. Kristen, I haven't forgotten you. Now, Kristen is something many of us in this field aspire to. She's a fellow in the College of Labor and Employment Lawyers. She's also the co-lead of Safarth. Okay. I need to really sharpen up my big firm name skills. Health Law Group. Kristen McGurn has for close to 30 years represented employers, and she's a partner at Safarth Shaw, and she's a co-author of Safarth's Vaccine Playbook, which I've actually looked at on their website, and it seems like what every employer is going to want in their book bag. Kristen has counseled employers on consistent implementation of lawful pandemic-related protocols, which I think is a way of saying she's been working on this day and night for 2 years. So we're going to talk first about employer policies and public health. And Seema, can you start us off? I'm thinking of the federal COVID-19 mandates, their status, which varies quite a bit, and how employers have been navigating them.
Thanks, Emma. And I'm really excited to be here. So thank you to Northeastern for inviting me. So I thought I'd start by talking a little bit about just the legal landscape for COVID-19 on the employer side. And just to kind of set the stage in terms of where things are, so I can talk you through what my experience has been like. So, as you know, there are 3 of the federal mandates that exist: the Osha ETS mandate, the executive order for federal contractors, and the CMS mandate. All of those that were going back and forth during the fall. And so, presently, all but one is kind of on hold or to stay. So the OSHA emergency temporary standard, which applies to large employers and which would have required vaccination or testing, has been pulled back after court challenges, is now essentially been pulled back by OSHA, although OSHA is still considering it for a permanent standard. So I'm sure there's more to come in that space. For the executive order for federal contractors, that has been enjoined nationwide. So that also is not completely over, and probably still more to come on that. And then finally, we have the CMS mandate, which applies to those healthcare organizations that have Medicare or Medicaid reimbursement. And that actually still exists across the country and in various states. And that's something Kristen's going to talk a little bit more about, but that is still out there. So I'm going to come back to all this in just a minute, but I wanted to just talk you through a little bit about what my experience has been working, both with 2 different types of organization, one that provided direct healthcare care, and then another one that's been the medical device industry providing indirect care. And I think, to say that has been a challenge to navigate these last 2 years through the complexities of a pandemic, while trying to keep your business up and running is an understatement. And I think it's essentially been, a balancing act of how do you keep going as a business, but how do you also, make sure your employees are safe, and not just because it's the right thing to do, but we have a legal obligation under OSHA's, general duty clause to keep the workplace safe. So it's been this constant, 2 very important priorities. And I think it's been different a little bit, pre-vaccine and post-vaccine, sort of the issues. Pre-vaccine, we were struggling with issues of, okay, we send people home, or, for those who need to be on site, we need to have PPE. We need to make sure that those, we are making sure that we don't, spread the illness. So we overnight, we were standing up, many places were standing up, employee health departments that they didn't have it before, but now they needed it because, we need to, how do you make sure people can be on site? We're listening to the CDC and the public health and trying to balance all of that in terms of people on site and letting them know that they need to be off site and when could they return. So those are the kinds of issues. But post-vaccine said another type of, issues came up. And that was really now, do we mandate or do we not mandate? And understanding the consequences of either approach, which, again, consequences in terms of OSHA obligations and safety, consequences in terms of maintaining a workforce, which already we had been struggling because from people who had been sick or had exposures and couldn't be out. So there was a constant, how do we do this in a way that we're not going to lose folks? And the other part of, for mandating, we were already in a situation where businesses were struggling because so many people were out for COVID. So if you decided to mandate, we had to think about, well, how do you socialize it? How do you implement it? And aside from even, issues and which we will be talking about in terms of accommodations, religious and medical, we just had fear and uncertainty from our employees about being vaccinated. And then on top of that, we had to deal with issues of, having a mandate that could potentially have a disparate impact on our workforce and, certain members of our workforce. And how do we address that and make sure that we aren't, we are being cognizant and addressing, those DEI issues in that space. And then on the flip side of it, if you didn't mandate, you still had to consider how are you keeping your workforce safe, right? How do you get back to work? Do you have the testing capabilities to test people on a weekly or a daily basis in order to get them back? Do you have policies? Are you enforcing them? How do people feel safe, whether you're vaccinated or not vaccinated, right? So really across the board. All of these decisions and all of these, whether you went one way or the other, and I was at, two different organizations, one mandated, one didn't mandate, but still a lot of the same ancillary issues, which, such as employee confidentiality of those COVID records, are not wanting, how do you make sure, your colleague doesn't know whether you've decided to get vaccinated or not, and making sure we're not treating people disparately or in a discriminatory way because they did or did not. Providing emergency leave and pay for those people who are out sick, don't have the time available to take time off. The impact of the childcare issues on parents, but mostly women in the workforce, and that's a big issue. So these are all issues that were happening and just compounded the COVID issues. So then the federal mandates come into play, happen, right? And the fall happens, and all of a sudden there's all these different mandates. And so then for employers who mandated, it was a matter of, okay, first of all, which mandate applies to us, and have we mandated it the right way? And getting ready to pivot and make sure we're doing things right. For those who didn't mandate, of course, they had to be prepared for a really big pivot to now mandate and figure out how to, again, socialize it, how to bring it out, how to do it and set it up and get ready. I think, most large employers were probably pretty happy when the mandates, the OSHA mandate, was pulled, and thinking, okay, this is great. I have to deal with it now. But the interesting thing is, the CMS mandate, people think just applies to, healthcare organizations, and that's not going to bother me at all. However, for those companies who provide indirect care, so for example, I work now for an organization that provides medical products, and is essentially a vendor for hospitals, and our employees have to enter those hospitals now in order to perform their work. So what this means is that the CMS requirement is actually impacting us now. And so because those third parties are now requiring their vendors, us, to make sure that our employees who are entering are compliant with CMS, and they're requiring that we sign an attestation that we've complied or that we have, provide an exemption. So even though we don't mandate, we are now having to mandate for a portion of our employees. So that raises a whole bunch of different issues in terms of, trying to explain to our employees that, no, it's not the employer mandating it. It's if this is part of your job, to enter a hospital, it's the hospital that's requiring you to enter. So there's a lot that is happening in this COVID space. And you're going to hear now also, in addition to the CMS, from Kristen about the state mandates, but I know I could keep going. I think that the pandemic, from a point of view, I would say, is that we've been thrown into a maze, and every time you think you've come around the corner and you've got it under control, something happens and you haven't. And I feel like there really isn't an exit to that maze. That it's here to stay, and we just have to keep adapting, which is what we've been doing for the last 2 years. And now it feels like it's just the way of the world. So, Kristen, I don't know if you want to talk about this.
So thank you, Seema. I think it's so interesting. It's always so interesting to hear from people who are like in the trenches actually doing this work. And I just wanted to take a minute and like shout out to the people in in-house legal departments and HR. Like I can't even imagine how the last 2 years have been for you all, because there's so much happening simultaneously, and the stakes are so high. I think everyone really is just shooting for workplace wellness and workforce health, and and driving, because those are such, our people are our best assets, and the stakes are high with respect to the Great Resignation. All of it is really coalescing, I think, at this point, and making the job of an in-house attorney or in-house HR folks just so much more. It's just extra. And so kudos to all of y'all who've been dealing with this for so long. But just to take a step back and talk a bit about what Seema was mentioning about the CMS critics, what's interesting there is I think it's a good indication of how industry by industry your experience may be different. And what happened with the CMS rule, certainly this also goes back to what Member Prouty was talking about in terms of rulemaking and proper administrative procedure, and how the ramifications of that can have impacted litigation, which we saw in the Osha ETS rule and also the federal contractor rule. But for CMS, what we found is in November, as Seema said in the fall, the U.S. District Court for the Eastern District of Missouri blocked the CMS rule. So even for healthcare in multiple states, which I don't need to name, but a bunch of them. And then the next day, the Western District in Louisiana issued an additional preliminary injunction suspending the CMS rule in other states. The U.S. Court of Appeals for the Fifth Circuit narrowed the Louisiana injunction. And then the Supreme Court heard oral argument sort of expeditiously, because we're talking about PIs, so the pace of litigation is accelerated. And on January 7th, the stay was lifted by the Supreme Court, effective January 13th. And what that means fundamentally is that 15 categories of healthcare providers who rely on Medicare or Medicaid federal funding need to comply with the CMS rules, which require vaccination. And some of the argumentation or the rationale that the Supreme Court relied on, focused on the fact that vaccination of healthcare workers against COVID-19 was necessary, they said, for the health and safety of individuals who care for and provide healthcare services. The Supreme Court said that spread is more likely in hospitals. A virus can spread rapidly among healthcare workers, and especially when those folks are unvaccinated. And there was an explanation that patients fear exposure in certain workplaces that can cause them to forego seeking medically necessary care, which results in further harm. So ultimately, it was found that ensuring providers take steps to avoid transmitting this dangerous virus to patients is consistent with the fundamental principle of the medical profession overall, which is first, do no harm. And so that was kind of the fundamental underpinning of the lifting of the stay of the CMS rule. I think as Seema pointed out, for folks who have adjacent responsibilities and need to get their people access into healthcare facilities that receive Medicare funding, it produces issues for them. It also remains necessary to consider state laws, and many states came out very early on and said, in healthcare in particular, we're going to ask our doctors not to, for licensing reasons, we're going to ensure that attestations and support for accommodations are legitimate, and we're going to ensure that certain workers in the healthcare space, notably here in Massachusetts, nursing homes, home care, those folks who are working with particularly vulnerable populations need to get vaccinated as well in order to provide safe patient care. Accommodating, of course, for religious and medical accommodations when lawfully required. But it's caused, as we said at the outset, just an enormous burden on employers to navigate the boundaries there and, to adapt to the changing landscape as these litigations ensued and regulations changed here and there throughout the last 2 years of this pandemic. I don't know, Gabi, if there's anything you want to add to that from your perspective.
Thanks, Kristen, and thanks so much. I'm very glad to be here. I think you and Seema really covered the substance of it. I mean, a lot of the issues touched on we'll get into whenever Emma says so, but for now, I thank you both for a very comprehensive presentation.
I agree. That was great. Seema, I just wanted to circle back to your incredible fortune in working in 2 different companies during the pandemic, one that imposed a mandate and one didn't. Can you help contrast those for us and sort of say, maybe troubleshoot for us if hypothetically we were trying to decide?
Yeah, well, I think that, one was a healthcare company. So, an organization providing direct healthcare. And I think that's different. In the sense that, your client is, patients and people, as Christian said, this is a vulnerable population already. Do no harm. There are already obligations there that exist that I think it's really a no-brainer in that context. Mm-hmm. That I think that, that COVID will become like the flu and the TB and these sorts of things that just, are going to be required as part of a job if you're a healthcare provider. So I think that was natural. I think the no mandate, arguably you could say, I think we are having to comply, like I said, in certain components, but, I think that where you don't provide mandates and have testing. So we have weekly testing. So there is a balance here that's being able to provide in an organization that's not mandating to ensure, or not ensure, to do its best to provide a safe workplace. So.
Terrific, thank you. I was just going to have a follow-up question about how employers are processing exceptions and exemptions, but I don't want to preempt Gavi. It's as our time is flying by. When it comes to employees and exemptions and accommodations, Gavi, can you walk us through some of the authorities and also some of your experiences?
Sure, thanks so much, Emma. In a certain sense, the issues that I'm seeing are the same issues I always see, which are, people who are seeking reasonable accommodation, people who either have disabilities or, have perhaps not a diagnosis, but some sort of issue that is interfering with their ability to perform their job. And, part of my role is to try to help them remain employed and be successful. Now, as Desiree said, I think it's in the air, and I love that phrase because it's true. It's in our practices, it's in our own personal lives, it's in the news. Returning to in-person work is the hot topic, and we hear from people who have existing disabilities. This is pre-COVID, who would have sought the reasonable accommodation of remote work in the pre-COVID landscape. Now we're also seeing individuals who are suffering from long COVID, brain fog, fatigue, et cetera, and also compromised immune systems that make a return to work really daunting, or as far as even medically an impossibility. So there are people with diagnosed disabilities. We're trying to work on reasonable accommodations for them. Then there are people who have serious mental health concerns, real fears about returning to the office. And some of them may be diagnosed with an anxiety disorder, others not. We're all living with a certain level of anxiety that we've had in the last 2 years. And the office reopening prospect can trigger that for people. So I try to help, work with my clients and their employers to see what level of accommodation can be provided, if any. And even pre-COVID, remote work, as I'm sure many of you know, was routinely considered a reasonable accommodation for certain disabilities, but I would say employers had often strong arguments that physical presence really was an essential job function. And I think that is going to be a tougher argument to make now that the workforce has been remote for so long. There have been cases both in Massachusetts and across the country, including in Louisiana, where courts have granted preliminary injunctions preventing an employer from terminating a telework arrangement for an asthmatic employee because of the employee's heightened vulnerability to COVID. In another case, court granted a PI requiring the defendants to allow a plaintiff with a pacemaker to continue to work remotely. And so I think, and I'm sure there are other cases that I don't know about. There's also been a somewhat more novel reasonable accommodation issue that I've seen, which is when an employee who is not disabled herself is seeking reasonable accommodation to care for a family member who is disabled due to COVID or other health issues. And at least one court here in Massachusetts, and district court, has held that the law does not go that far. There is no claim for associational failure to accommodate. And I imagine that other courts will follow. I don't think that's much of a surprise. We've also seen, a few months ago, we were getting a lot of calls from employees who were seeking medical or religious exemptions to vaccine mandates in particular. And I haven't gotten any recently, and I was thinking about why. And I suppose it's because they either complied with the policies or left their jobs, either voluntarily or were terminated, now that these many mandates have been in place for some time. Relatedly, some of you may have heard that the Supreme Court recently denied a cert petition filed by employees in Together Employees versus Mass General Brigham, where the First Circuit actually in November had denied plaintiffs' request for a preliminary injunction to halt their healthcare employers' mandatory vaccination policy. They had made medical and religious arguments for exemption, all of which were rejected by the court. And I don't know if I'll pause here and take a breath, see if Seema or Kristen, either of you has anything to share specifically related to religious exemptions.
So I was going to just say that, it's a really interesting area, and I think religious exemptions hasn't been discussed as much. It has been discussed in the last several months, and I think, for employers that mandated and needed to go through the exemption process, and I've had discussions with multiple colleagues from different places, and it was an interesting discussions because I think there was a lot of concern that people would the religious exemption would be the catch-all, but if they just didn't want to do it for political reasons, social reasons, fear, whatever it might be, that would be the avenue people might use. And so I think there was a fear that, okay, that's going to happen. So how do we prevent that from happening, and what approach? And I think, different employers with different approaches. I mean, I think there were some that just allowed all the exemptions because they were, again, fearful that people would leave or be terminated. And they're thinking about the workforce and needing people to work. There was that. And I think there were places that decided that, okay, if it wasn't, a particular religion that was, part of an organized religion that specifically did not, approve of vaccinations, like, Christian Scientists or something very specific, then we would deny it, or being very narrow. I personally don't think either of those approaches were the best practices. The EEOC came down and gave some guidance, which, was great. I mean, I thought it was great. It was something. So, which was basically, that, you should assume that that a request for religious accommodation is sincere, just assume it. And then, however, if there was something in there and in your interactive dialogue that came up that, you objectively raised the question of whether it was sincere in terms of, whether, maybe it was that something they said that showed that they had acted differently and inconsistently. So for example, I know one of the common reasons why people asked for the religious exemption was that it was, my body is my temple and I don't want to put anything in it that might be. And so, if people had taken the flu vaccine before, it became a question, well, if that was okay, why is this not? So, I mean, there were reasons to objectively question, sometimes, and the EEOC was saying itself, timing, and not timing alone couldn't be an issue, but timing could be one factor. And if there was anything in there, that an exemption for political, social, or economic reasons are not religious. So I think there was a lot there to work with, but it wasn't, as with any accommodation request, it's very fact specific, and you need to do the work and go through the conversation and, make sure, if there's a reason you're going to deny it, there should be a reason you can point to, it shouldn't be just because I don't know what that religion is, or, that's not the approach. You accept it and go from there. So I think it's really interesting area, but yes, I think those are some of the ways that I know employers have handled those requests.
And I'm not going to comment on that litigation specifically at all, but I just wanted to also point out that in the EEOC's technical guidance, they also noted that if an accommodation sought a particularly desirable benefit that is likely to be sought for other non-religious reasons, that might be a reason to objectively question the request for exemption. So there were, as Seema said, I think employers were hungry for guidance, and it was a moment of gratitude when the EEOC came out with that technical guidance. I think the only other point that I wanted to make that I think still is plaguing employers is for those who have locations, work sites, and employees in various jurisdictions. It's a unique challenge because now with the withdrawal of the Osha ETS and the lack of clarity on the federal contractor guidance for employers outside the Medicare, Medicaid reimbursement context, those folks are still now navigating this landscape with multiple states passing legislation like every day now that relate to which types of accommodations need to be considered. Is conscience sufficient? Does it need to be strictly religious? Can you even ask for proof of vaccination status? What are the consequences if you navigate those tricky waters improperly? All of the shifting landscape in states as well becomes relevant for national employers who have workers all across the country. And to navigate that, very much like the paid sick leave legislation, it's very challenging patchwork to navigate for employers in this space. And so, we're tracking that kind of state by state legislation, but right now, Alabama, Arkansas, Florida, Iowa, Kansas, Montana, North Dakota, Tennessee, Texas, Utah, and West Virginia all have some kind of legislation that would need to be taken into account if you were trying to roll out, global policy consistently across the national landscape.
And the one thing I'll just add to that point of the CMS is that if you're on the independent contractor side of things, so again, if you're the vendor going to a hospital, there have been some, they're not subject to these these rules, right? So there's some employers that are saying to the vendors, you need to be vaccinated, no exemption, you need to be vaccinated. So that's another side to it as well. And all of this is that, you may want an exemption, but depending on which side of the coin you're on, or who you are relative to who's requiring, it varies.
oh, go ahead, Emma.
No, go ahead.
I was just gonna add that I think this period as an employee advocate has been really uniquely challenging for me personally, and I think I'm not the only one, because my goal is always to advocate zealously for my clients, trying to get them reasonable accommodation to the greatest extent possible. And when I was getting those calls from people, I'm really glad they stopped, because I was getting calls from people saying, I don't want to get vaccinated. My employer has a mandate. What do I do? And I just didn't want to take those cases, from a public health perspective, from a personal perspective. That wasn't where I wanted to put my energies. And I think a lot of folks on my side of the bar were struggling with this. There were lots of heated arguments on both sides, because I do think people should get representation, but also public health crisis, global pandemic, et cetera. Is that really where we should be putting our resources? So on a personal note, I am glad that those have died down, and now we're turning to some of the meatier issues that I think are a lot tougher to answer. What's an essential, back to what we used to do in a sense. What's an essential function of the job? What really qualifies as a disability, especially when it comes to these mental health issues and just the anxiety that is permeating the populace related to going into the office, and how that relates to the vaccine mandate, masking mandates, et cetera.
And what's an undue hardship? What does an undue hardship really mean? And especially when we're talking about a public health crisis. Yeah.
I'd be curious to know how you're all navigating the fact that the types of disabilities can be different now, that folks might have had latent conditions employers didn't know about that are highly vulnerable in the COVID world and now are seeking recognition. And other folks who might be identified as disabled to their employer that has no connection to COVID. So have you, I don't know, Gavi, had any challenges in negotiating with employers or presenting to judges in accepting what these new conditions are that should be recognized?
I haven't yet. I mean, there are many things I tell my clients I am not. I am not a therapist. I am not a tax expert, and I am not a doctor. So if they have medical support, and that's what I wasn't seeing in the vaccine exemption situation, there was not medical support there. Here, as always, if I have a doctor who is saying, yes, my client, my patient is suffering from X, Y, or Z, and that makes him or her more vulnerable, or makes return to the office more difficult, that's enough for me, and I can use that effectively to argue, or to make a compelling case to my opposing counsel.
But, the CDC really, the contraindications were very few, and really the CDC was encouraging lots and lots of people to make sure they got vaccinated for serious health, for reasons that related to their own personal health. So I think it was an evolving landscape. It's a challenge. Again, I think there's, we should just acknowledge that there is also, case law being developed out there about whether COVID is a serious health condition under the FMLA, whether, long COVID is going to be a disability. So the law continues to evolve. And that's one of the things that I think has been so interesting about this past couple of years is, we've had often, if you've been practicing for a while, you have to pivot your practice to where the clients need you. And this is in spades, one of those areas. And I think it's going to continue, as Gavi said, that we're not there yet. Those decisions are evolving in active litigation that is going to go on for some time after this. And, in the meantime, we have to get, as Alcina said, we have to get back to work and find a way to maybe break some of our COVID habits and return to whatever normal is going to be post-pandemic. And to me, that's like the next frontier, is how employers are going to, get everybody back and be where they want to be. Kind of, who do they want to be when they grow up post-pandemic?
And post-pandemic is
I would also.
Go ahead. I'm sorry. Go ahead, Gabi.
I always talk over people on Zoom. I would add that, in thinking about what's considered a disability, right, I try to break it down into its component parts. So I care less about, the name, like, is it long COVID? Well, you're experiencing fatigue such that you can't sit at a computer for 8 hours a day. Okay, that sounds like a serious health condition, right? Brain fog similarly, and other issues that I've seen clients struggling with. So it's possible that courts writ large are still debating, whether long COVID in general or COVID in general is a disability, but the functional limitations are what I try to focus on in my practice. And those, those may have bear relation to other diagnoses that have previously been clearly recognized as disabilities.
Mm-hmm. That makes sense to me. What mechanisms are employees using or employers using to process requests for accommodation? Or those may be in place, but process requests for exemptions from vaccinations, for example, as someone who spent a lot of time in administrative hearings and arbitrations, I'm just wondering how fact intensive is it? I'm interested to hear more.
I can say for, I think that, I think it's changed a little bit. I think because we were dealing with a lot more requests, right? But my advice had been, and this is not legal advice I'm giving to anybody, I'm just saying my practice, is that I think that, it's important to be consistent and fair in how you are handling these requests. So, and I'll just speak generally, when I worked for the healthcare organization, which had sites all over the place. And, typically requests for accommodations were, it would happen, but then they'd go up through each kind of region. But what we did and what I recommended was that stop, and that for this, we have a group that handle all of them. That included an attorney and relevant HR folks, and that we had a process that everybody went through the same process. And it was very clear about, what the steps were. And then the evaluation happened, and I think that did help to create consistency in the decisions and how we did it, and to be fair. And I think, and to go through, again, it took time, but, at a core, each of those was a request for accommodation. And what you do in a request for accommodation is that you have the dialogue and you work through and try to figure out something, what the situation is. So I think, so that's, been my experience in terms of handling these.
And are there safeguards to protect against intrusiveness that could be considered illegal? Obviously, medical and disability related discussions and negotiations have been going on for some time, and in some settings, religious exemptions as well. But I know even outside the public sector, where as state actors, constitutional objections could be raised, even in the private sector, I can imagine employers being reluctant to ask people about their religion. And how do you do it? Do you do it with a form or interviews or?
I think it's important to keep managers out of it. And I think it's really an HR legal function is what I would say. And I think that's the best way to safeguard the confidentiality of the individual, and also to actually, frankly, to protect the managers, right? They should know that information. And should there ever be any kind of adverse employment consequence, you never want them saying, employee potentially saying, hey, you knew XYZ and you did it because of that. So I think, managers shouldn't know. It should be outside of that process.
And I wish that all organizations were as clear about that separation, because employees want that too, for obvious reasons, and always, I've seen with my clients a lot of struggles. What do I say to my manager? They're asking how I'm feeling, like how far do I go? And it's just it's awkward, as it always has been, but it's obviously heightened.
Yeah. And I think managers need training. So, it's just a space where they need to understand what's appropriate and what's not, and what they can and cannot do. And so, and that's fair. It's a gray, uncomfortable area. They want to know how many times it's coming from a good place. And so, But there are rules, and so they need to be educated.
And my former colleague, Laura Matsumi, is in the chat. She's asking a good question. What if you don't have a separate HR because you're such a small organization? So many nonprofits and businesses fit in that category and aren't able to garner their own resources to stand up a system like this. Do you have sort of guiding advice or perhaps Gavi pitfalls?
That's a good one and a tough one, but I think if that were the situation and they're really, I think I would, at least try to, if you could take it out of the line of management somehow, right? Where it's somebody who's going to be making decisions, employment decisions related to this individual, their advancement, or, is there somebody you can designate in this role, right? Somehow to keep it out, because I think it's risky. I'm not sure there's any other way. I mean, if you have to have that manager do it, I think it's very risky.
And I would add also, hi Laura, that I think, and this is true to prevent so many issues in the employment relationship, but having objective measures that are, that and the employer sticks with consistently, that the employer can fall back on and use as a guide to help themselves, and also to help employees to reassure them that they're being treated equitably. For example, if there are clear objective standards for discipline, and those steps are followed even after a person has, let's say, requested reasonable accommodation, it's going to be a harder case for the employee to make that it was retaliatory. Whereas if there's a real departure from those standards, or those standards don't exist, and there's rampant, subjective evaluation, I think that's a big pitfall for employers that I've seen.
Mm-hmm. That makes sense. So even a small organization could be proactive, even if they were fairly simple standards, so that they could at least demonstrate they were applying them in that way. And Kristen, I was hoping you could bring us back to the future and tell us a little bit about what you see in the next few years in terms of both employee wellness and also the continuation of litigation that's underway. Oh, I think you're muted at the moment.
No, I'm not. Sorry about that. So you'd think I would have figured that out in 2 years, but it seems like a daily event. So I'm unmuted, and I'll just say, like, looking at what we're, kind of what Gavi has said, I think we do have to recognize that, our workforces are struggling. This has been hard for everyone. What I see, just as in my, role as a manager, is that, there are some people who miss their colleagues and want to get back together. And so the questions really become, how do we return people to the office when we're faced with some anxiety and fear, and how can we keep that workplace safe and make sure that from an OSHA perspective, we're taking care of the people who work for us, and how can we accommodate the leaves that are going to be necessary when people, get COVID or the kids are sick. And all of these things really have been a tumultuous but a changing landscape for employers to deal with. I see a lot of folks focusing on wellness, and especially, for the healthcare providers who've been on the front lines for so long, how are we going to make sure that those folks remain strong and get the recognition that they deserve for, the work that they've been doing, and remain healthy doing that work, and keeping our patients safe and healthy doing that work as well. But the same goes for an office environment where, management is understandably concerned about, how are we going to bring people back together, perhaps when Omicron is a bit of a memory, and, we have perhaps a little bit of a window here to get ourselves into the spring and summer with some less trepidation about being together. And then, how do we keep people engaged if they're not physically together? And what does that, what are the efforts that employers can undertake to ensure that, employees feel that their best interests are being taken into account, that they're satisfied with their work, even if they're distant from colleagues, that communications about expectations for returning to work are clear and measured, and give people enough time to plan for childcare and things that they need to do to change their pandemic patterns and get into what's the kind of new normal. Making sure that EAP services are adequately supporting the mental health concerns and anxieties that have been produced and will continue, and just generally finding a way to make sure that folks feel inspired to get themselves back to the work that they need to be doing. It's, I think it's going to take some time. I think it's really a function of change management, and I think there's still work to be done, but I feel like most of the clients that I'm hearing from are turning the corner and getting ready if they haven't already undertaken these steps, but are really trying to envision what tomorrow looks like and trying to get people ready for that.
Thank you so much. I want to be sure to leave time for everyone here. I know we've all devoted a big part of our careers to the American workplace and everything that goes on there. And I'm sure you yourself are working for a living if you're anything like me. So questions, thoughts, feedback, responses, the floor is yours. You can either raise your hand, put something in the chat, or frankly, just jump right in.
While we're waiting for the first brave soul, I would just add that, what's also in the air right now is the amount of movement in the labor force. And so, as Kristen was talking about ways of supporting, employees returning to work, I think it's also in terms of thinking about retention and getting new talent, especially young people and people with caregiving responsibilities, developing some sort of hybrid. I don't think we're going back to the way things were. We have to create some new type of work. I was reading an article, this morning about Gen Z and their struggles and expectations, and these are real issues that we're all going to keep seeing for a long time to come.
Yeah, I think the question, at these interviews from employers will be not, do you have a remote work policy? What is your what is your remote work policy? Things have changed permanently in a lot of ways, and so I think employers have to adapt and find that sweet spot, which I think is going to take some time.
Yeah, absolutely. Zach?
Yes, thanks. I have more of a comment that I'd just like to hear your reaction to. I think one of the interesting things about COVID has been the necessity for all of us, but then businesses and organization to adapt to changes in science as we learn more. And a lot of businesses and organizations don't do that very well. In fact, are best when they kind of set long-term policies. And so just for an example on COVID, one organization I'm familiar with was had very strong vaccination mandates. And then when Delta and Omicron came around, and employees started calling in sick for breakthrough cases, started demanding that these employees give doctor's notes because they were convinced that the vaccinations had solved the problem. So employees must be, making stuff up. And it just, that it made sense. It just wasn't, they weren't reacting quick enough to science. And so I'm just curious what folks' thoughts are on how to best navigate that.
Well, I think that, the pandemic has taught us that we, as an employer, the emotional, physical health of our employees is a real thing that we need to be on top of. And like I said, I know organizations that had to create an employee health because there was no other, and to have, the council of, healthcare professionals to provide guidance because nobody else in the organization can provide that. And so it might be something that, employers just need to either on an outsourcing basis or somehow to be able to incorporate that, to be able to navigate it, because it is, unless you are a medical professional, I don't know how you make those decisions without some support and advice.
Yeah, I think, Seema, the one other thing that I saw a lot of employers doing is sort of leveraging their leave administration and sort of the experts that they have within their
in the healthcare space, right? I mean, you may not have that in a non-healthcare space, I guess is what
you probably have like a TPA who's administering your short-term disability or long-term disability, and so to access those professionals.
Right, that's true.
Right?
Yep.
And that's sort of, I saw a lot of that workflow modification to kind of leverage the expertise that you can find adjacent to
Right.
Well, thank you. Jeff's raising his hand. I'm actually going to pass the microphone to him anyway, so it's redundant. But I just want to thank these panelists, Gavi, Seema, and Kristen. It's been such a pleasure working with you. I would be thrilled if I needed a lawyer and I got to have one of you as my lawyer. That's how I feel often when I'm around my Northeastern colleagues. I'd like to turn it back over to one of our conveners, Jeff.
Thank you, Emma. And I actually do have a question, and it's really Gavi was talking about retention issues, attraction and retention, which was the question I was going to ask, and sort of just because I advise and represent employers, and as I think it's common knowledge, there's really a shortage of qualified workers in every industry. Businesses are struggling to attract and retain workers, and I'm wondering, I guess mostly from Seema and Kristen, what have you seen in your companies or your clients? What kind of tools, besides some of the things Seema mentioned, in terms of, getting employee input into what the policy should be without sort of letting things go too haywire, I have seen employers using questionnaires to sort of see, or convening monthly or quarterly meetings to get input and feedback, and what tools have, as opposed to just doing a top down, this is how it's going to be, like what have you seen work?
Yeah, I mean, we've done a lot of, in both places that I've been, employee engagement surveys, or, and trying to, periodically really to kind of see how people are doing, especially throughout the pandemic, and responding to that, and trying to really get to the voices of people, and not just assume that we know, because we don't. And so I think that's important. And so, and I think, I haven't been involved in those, but I think, opportunities to get, groups together to speak is great. But I think that, the more you're checking in with your employees, that, it shows them that you're, I think it works both ways to understand and respond, and to help people, let people know that they're being heard, right? And about what is concerning them. So.
And I'm also seeing, Jeff, sort of do you have what you need to be successful? And if not, what is that? So that it really gets the employees to be thinking about what that is for them, which I think, builds engagement and is the listening part that Stephen just mentioned, that I think is so important. And then, I think the other piece of it is to recognize that what you have or had growing up through your role isn't necessarily what they want. So being able to flex your management style to what is going on right now in the world, I think is really important and hard for people. It's hard for, me, an old timer who's seen a lot of stuff, to not automatically presume that, of course we should be back together, because that's how one learns how to become a lawyer and meet clients. And you've got a whole generation of people who have a different opinion about that, and it will change, so there's just the ability to be flexible and agile and ask the questions and be listening, I think is really all that we can be doing now. But we're seeing tons of surveys, absolutely. And then yesterday, when it was 70 degrees, we took everyone outside and had a picnic. So that was awesome. The very few of us who were actually together, but it was fun. So we're trying to get back,
Nice. Well, thank you. Thank you for answering the question, and thank you to the panelists for a wonderful, wonderful program. I also want to thank Miel for all her work in putting together this program and so many other programs that and doing all she does for the alumni. She's really incredible, and I'll just turn it over to her for some closing comments.
Yeah, we're so pleased to have had both panels with us tonight, and appreciative of the moderators. So thank you, Valerie. Thank you, Emma. It's so great to be back in touch with you, Emma. It's great to have everybody join us. I know it's a little bit challenging after work, but we hope you got a lot out of it. I know I did. Appreciative to have Member Prouty with us. Always special to see Mark Irving. So thank you, Mark, for joining us and for all you've done. I did want to mention we have a terrific event celebrating the many accomplishments of Carl Clare coming up on April 8th. It's a full day conference. I hope many of you will join us for that. We're going to celebrate Carl and all that he's done for this field over the past many decades, Carl. So thank you. I hope everybody joins us for that, April 8th. There's a lot of information on our website, and just grateful to the speakers tonight and to Jeff and Josh and Stephen for planning a terrific program. So thank you all.